Oh yay, the Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Busk. Good afternoon. My name is John Bailey. I'm the Chief Justice of the Eastland Court of Appeals. I'm joined today by relatively new appellate court justices, Stacey Trotter of Odessa and Justice Bruce Williams, who came to the court from Midland, but is now a proud Eastland County resident. At this time, the court will call calls number 112044CV in the matter of the guardianship of Stacey James Browning. Mr. Wymore, are you ready to go?
I am, Judge.
You may proceed.
May it please the court? Gentlemen, thank you for your time today. I want to start off by addressing the fundamental issue of this case, which is the interplay of sections 1055.001, 1055.003, and 1203.052 of the Estates Code. Very clear position on our part. 1055.001 does not apply. 1055.003 and 1203.05 do. In looking at 1055.001, it's clearly titled standing to commence or contest a proceeding. And when you break down the language of that statute, I think it becomes clear why it doesn't apply. What it says under subsection A is that any person has the right to do two things: commence a guardianship proceeding, which includes a restoration proceeding, or a modification proceeding. Second thing is that anyone may appear and contest a guardianship proceeding or the appointment of a person as guardian. What subsection A giveth, subsection B taketh away. What it says is a person that has an interest that is adverse may not do one of four things. Now, appellees have glommed onto one section, subsection B3, which says one with an adverse interest may not contest the appointment of a person as a guardian of a proposed ward or an incapacitated person. Very important language. The Estates Code specifically defines these terms. 1002.017 defines incapacitated person, 0026 defines proposed ward, and 030 defines ward. A ward is a person for whom a guardianship estate already exists. Subsection 3 does not apply to a ward, merely a proposed ward or an incapacitated person. What I'd ask this court to look at is subsection
4. Does subsection 4 apply to a ward?
Yes, it does, Judge. And that was the point that I was going to get to next. That's the distinctive language that you've got to look at. The legislature clearly said contest of an application for complete restoration applies to a ward. The other sections apply to the inception of a guardianship. If the legislature wanted to make subsection B3 applicable to a ward, they would have. But the reason that they didn't is because there's a different statute. Subsection B3 does not apply to removal of a guardian. Subsection B3 applies to the appointment of a guardian. If you want to look to what the legislature said for removal, look to section 1203.052 of the Estates Code. Appellants are not doing anything envisioned under 1055.001. If you look at the top of page 16 of Appley's brief, this is where I think.
Let's go back to 001.
Yes, sir.
You, in making your motion, aren't you attempting to modify the ward's guardianship?
No, Judge, we're not. And here's why. A modification would be someone seeking to alter the care, someone seeking to shift the investments. So in other words, if we were to say that Mrs. Browning is doing, there's not appropriate care being provided to the ward, and we said something different needs to happen with the care of the ward, that would be a modification. The legislature clearly provided a different mechanism for removal, 1203.052. That if that were deemed a modification, then they would have expressly laid it out. They didn't. These are different statutory sections, we assert, for those reasons.
Okay.
Because it's not, yes.
So let's look at it for just a half a second. Do you agree with me that 1055-001 prevents an adverse party from coming in and proposing who the initial guardian should be or should not be?
I think that's a fair reading of the statute. At the inception, but before the guardianship has been created, only while an application for creation of a guardianship is pending.
Okay, what about in this case where we have the initial guardian is the father, he dies, and another guardian is appointed? Do you believe that that section prevents an adverse party from coming in and contesting who the new guardian should be?
At the time that she was appointed in 2015, that argument could have been made. This is not a contest to appointment. This is an application for removal under 1203-052. Two very different things. 001 applies to appointment, 052 applies to removal.
So, okay, what about the week after the guardian is appointed? You can do what you couldn't do the week before on the guardianship. You could say, wait a week for the guardian to be appointed and then come in and say, there's nothing now that prevents us from coming in and say the guardian should not be appointed.
You would still have to qualify as an interested person under 1203-052.
Right.
I mean, there's still some impediment,
yes,
Judge, but the idea is there's still two different mechanisms. Now, I mean, there's any number of specious scenarios that we can raise, and I don't think any decent human being dealing in good faith is going to lay behind the log and then 1 week later, after the appointment, spring forth and say, I've got something for you to consider. That would not be well taken. But that's not what this is. We had hundreds of bullets being shot onto our client's property and a guardian that ignored a district court's decision for over 8 months, despite an acknowledgement of danger.
Okay. Isn't your remedy in that court where you filed your lawsuit in Williamson County?
There is a remedy there, Judge, but here's the question. As Justice Bailey, as you aptly wrote, if we're looking at 1055-001, Justice Bailey, as you wrote in the EMD opinion, the section is intended to look out for the ward. That's the overarching goal here. And that was what was written last October. Well, we've got a guy that we submit is being subjected to real danger. Now, we can litigate all we want in Williamson County, but there's a guardianship proceeding in Scurry County. And
do you agree you're an adverse, you would qualify as an adverse party? Absolutely
not. And this is, again, looking back to the N. Ray Thetford opinion,
right?
That was, this court adopted it. Again, Justice Bailey, in the EMD opinion from last October, this is what was held. We hold that for a guardianship proceeding to be adverse, and again, this is envisioned under 001, the language is slightly modified. The interest must be adverse to the ward's objectives or interests as the ward would have defined them when he had capacity, in the absence of evidence of how the proposed ward would have defined his interests. Adversity exists when the movement's interests would not promote and protect the proposed ward's well-being. Well, Judge, we are protecting the ward's interest and well-being. Put aside all of the other cases that Appley cited. What they cited, the Gilmer case, the Benavides case, the Valdez case, all of those cases dealt with partially functioning individuals that still had the ability to marry, maintain relationships, engage in business some form or another. What we're dealing with here is a man, I believe in his late 40s, who has been wholly incapacitated for over 30 years. It is impossible for any of appellants to have an adverse relationship with Ward. And by the way, Judge, when we look at the statute, it doesn't require an adverse interest with the estate, the guardian, the guardianship estate. It specifically requires an adverse relationship with the ward. And when we look at that, the factual scenario in front of us, this is
the ward can only act through the guardian, right? And the ward can only be sued through the guardianship estate, right?
Correct. But if you look at the language of 1055-003, what you will see is the statute expressly requires an adverse relationship with the ward. Now, the legislature could have included the language. They could have said guardianship estate. They could have said guardian. They could have said they could have used any of those other specifically, clearly defined statutory terms. But the term that the legislature picked is ward, and ward is defined under 102030. That is the clear, specific, and direct party with whom an intervenor or proposed intervenor under 1055-003 must have an adverse interest. That adverse interest must be something that is opposed to the ward's best interest. So this gets to the question, what is the ward's best interest here? Well, the unrefuted testimony from the hearing in Scurry County, the guardian testified three things at reporter's record 141 to 154. She said the range is of no benefit to Stacy Browning. She said all of the profit from the range went to someone other than Stacy Browning and the estate. In this case, it went to the guardian's daughter and son-in-law. And she also said the only benefit that the estate received from the range was a $1,600 a year, not a month, but a year rent payment.
Okay. Monetarily, he may not be getting something from that, but this is his sister, correct?
Yes. And Judge, ultimately, an estate doesn't get free rein to say, we're going to give opportunity to family members. You don't get to use the estate's money however you want, which is ultimately what happened. Now, again, not only did the estate receive minimal financial benefit from this, the other problem is they have great exposure, unbelievable exposure. Think about it. We went in front of Judge Kennan in Williamson County and we secured a temporary injunction, and the temporary injunction order says the range presents a danger and threat to human life, not only to those on our client's property, but to those on the neighboring county roads and railroad tracks. There is an admission in the record that what they were doing presents an existential threat to human life. So the question is, Judge, they were receiving a grand total of $1,600 a year. And in exchange, they were receiving a boatload of exposure. Why were they doing it? That wasn't in the ward's best interest. The most baffling thing to me.
You received injunctive relief in Williamson County.
Yes.
Why not? Because you did. Why didn't you pursue your other remedies in that court?
Judge, we will, but the estate's code mandates that if you've got a complaint to make in a guardianship estate, you've got to do it within the guardianship. There's a human aspect to this case, and appellants and our clients said, this isn't right. They are operating this range that is highly dangerous. We have over 100 bullets admitted into evidence in Williamson County. The judge acknowledged that this is dangerous. We got to shut it down. And when Pam Browning as guardian didn't stop it, we said, we need to tell the folks in Scurry County about this. The county judge needs to know. The guy presiding over the guardianships needs to know. Why? Because at a very human level, the guardianship doesn't need to be doing something that is highly dangerous and of no benefit to the ward. We can go win every day of the week and twice on Sunday in Williamson County. That's not the issue. The issue is that
The fact that they have been paid some money back, the fact that they haven't been paid back yet doesn't mean that it will not ultimately be to the benefit of the ward. Is that correct? They could sell it and sell it for a profit, and that would be for the benefit of the ward.
Judge, it's already been sold.
Okay.
It's the land has already been sold. Again, I don't think that the estates code allows us to envision ways in which this may benefit the ward. The facts at hand are the facts that we know.
Okay, I want you to get to what you think allows you to get between the guardian and the ward. You as an adverse party, there's case law, and I'm sure the other side has cited it to say when you have filed a lawsuit against the estate, you are an adverse party to the ward. Go ahead.
Judge, I don't think that's correct. Every case that appellees have cited, looking at them, we've got the Allison v. Walford, Gilmer, Benavides, Valdez. All of those cases apply only to 1055-001. We moved to intervene under 1055-003. And the plain and clear language of 1055-003 allows intervention. What it says is
it allows you to apply for intervention, right?
No, it says an interested person may intervene, and the intervention may be denied in one of two scenarios.
Exactly.
If the intervention will unduly delay or prejudice the adjudication of the original party's rights, or the proposed intervener has such an adverse relationship with the ward. In this case, there is no adverse interest with the ward.
How does anybody have an adverse interest in the ward with someone who's incapacitated?
Well, Judge, here's the example we cited in our reply brief, and it's a bit hokey. The Britney Spears guardianship, Judge. It's probably the most high-profile guardianship in America over the last decade. She is a ward, but she travels the world. She tours. She makes hundreds of millions of dollars. She has business relationships. She's capable. If we reduce this down to saying every ward is wholly incapacitated, then, obviously that I think that misses the point. Most wards are capable of maintaining relationships.
Okay, make your argument on 003, please.
There was no evidence presented of undue delay or prejudice to the adjudication of the original party's rights. The two claims that were made is that we may not be able to buy a piece of property, and we may not be able to file our annual accountings. The exhibits that we provided this court show two things. During the pendency of the motion to intervene, there was no application made for an annual accounting, and there was no application made to buy property. The problem is they weren't complaining that the intervention, and again, that's what the statute requires. It says you must show that the intervention in and of itself will unduly delay or prejudice the adjudication of the original party's rights. They didn't say the intervention would. They said that the pending motion to intervene was preventing things from happening, although they never tried to do this.
So under 003C, are you saying 1 and 2 are the only things that the court can consider, or the two things among the many things that they consider that they must also consider?
Judge, I don't know, because a court cannot have unlimited and unbound discretion. I think the legislature defined those 2 points because those are important points, and that a trial court's decision should be limited to looking at those 2 things. And the fact is, there was no evidence presented that the intervention, in other words, let's assume the intervention is granted and appellants are now intervenors. What's the delay and prejudice? They didn't point to anything. All they said is that the procedural existence of a motion to intervene was causing some sort of alleged delay, although they never filed anything. And they said, you're adverse to the ward. Well, no, we're not. Judge, all we're trying to do is get this information in front of the court. The barrier to intervention should be low. Our client doesn't take this lightly, but is trying to present important information for the benefit of the ward, to make sure that the right thing is done, to make sure that funds aren't used in an improper manner, to make sure that the public is protected. That should be prized.
Don't you have that remedy in Williamson County
No.
to ensure that you don't have bullets coming over into your property? Isn't that what you're interested in?
We're interested in that, but we're also interested in following the rules under the Estates Code, 1055-003. The only option that we have, Judge, this is it, to present the information to the county judge in Scurry County. And by the way, he's recused himself, and there's a Judge King out of Fort Worth who is a 30-year probate expert, and by the way, has seen this estate to be in such a state. He's appointed an ad litem. You're aware of that. And by the way, ad litems aren't appointed unless things are not going well.
Okay, those are post-event occurrences, and I want to know at the time of the incident, at the time of the judgment, what the facts were. I think the post.
At the time of what judgment, Judge?
At the time the court made the judgment that sanctioned your client.
I don't understand your question.
I'm just saying, Judge King was appointed after the judgment, after the appeal in this case, correct? Okay, all right.
Yes, that's correct. Now, but the idea is that if you want to get information in front of a probate judge, in front of a judge who is presiding over a guardianship estate, you don't do that in a separate legal action like the one we've got in Williamson County. There was a problem. The folks in Williamson County, Miss Browning as the guardian, she acknowledged the existence of the judge's decision. At the hearing, November of 2019, she said, yes, I'm fully aware of the judge's decision prohibiting the firing of rivals. I'm fully aware of that, but I thought it was just a suggestion. We can't try and help correct the problems with how that guardianship estate is operating. We can't help try and correct that blatant violation within the actual estate unless we bring it in front of the judge.
Yeah, but you don't, but you're not just bringing it in front of the judge, you're asking that the guardian be removed.
Well, understood, but if you look at the way that hearing broke down, the issue of removal was not addressed in November of 2019. What the agreement was is that the hearing November of 2019 would simply focus on whether or not intervention would be allowed. And we met that standard. Here's why.
All right, you'll have an opportunity to reply. You're 3 minutes over, and it's my fault. I'm sorry.
That's okay. Thank you, Judge.
Yeah.
Thank you very much, Mr. Wymore. Mr. Odell, are you ready to proceed?
Chief Justice, I am. Thank you very much. May it please the court. Appellants are here asking this court to accept a position in this matter to essentially circumscribe and change the way the legal system in many ways works, in particular for guardians and guardianships. And what I mean by that is that they're asking this court to essentially allow a party who has a lawsuit against the guardian, and in particular against the estate, since as Justice Williams pointed out, you have to sue the guardian. in hopes that they may be able to have her removed, a new guardian appointed, one in which may be favorable to them, so that the litigation down in Williamson County becomes much more simpler. However, as this court is latched on to and noted, the question here starts with section 1055.001. And that statute deals with a party's ability to come in and have standing to commence or contest a proceeding. Now, appellees would have this court by the position that it only means the commencement of the case. And that whenever you're looking at B3, that only means whenever you're first appointing the guardian. However, that's not what it says. It says to contest the appointment of a person as a guardian of the proposed ward or incapacitated person. And I think that's important to focus on.
Okay.
First, contest.
Mr. Odell, the cases that we've looked at indicate that it's been used when there's an application for guardianship. That may be just the facts that were present at the time. Do you have a case in which 001 was used at any time other than the commencement of a guardianship?
Your Honor, I do not have a case that specifically deals with any time after the commencement of a guardianship. However, a case that was actually cited by the appellants in their brief specifically states, and this is the Betts versus Brown case at 2001 WL 40337 at 2. And this is the court saying, additionally, and they're referring to the old probate section. This was prior to the recodification and the creation of the into the estates code. And it says, additionally, section 642, or other words, 1055.001 encompasses more than one than who has standing to apply to be appointed guardian. And it talks about the fact that there's different things that this statute applies to. And it's not just the beginning of the case or the first time to be applying for the guardian. As Your Honor pointed out, it refers to modifications and having the guardianship modified. And to sit here and argue that seeking to have the guardian removed is not a modification of this guardianship, I don't know what more modification you would have. It's seeking to have the person who's responsible for caring for the estate of the guardian or the ward, and as well as the person, to be removed to no longer be a part of this guardianship. That's a modification. If I were to file an application for a successor guardian, I'd be modifying the guardianship. So even going to B4. And it specifically states that you cannot have an adverse interest. And the cases, as been brief and as pointed out therein, and as already referenced by appellant's counsel, stand for the position when you have a lawsuit pending in which you're seeking damages against the ward, then you've got an adverse interest. And that's what we have here. We have Mr. Dickens and his companies suing the guardian down in Williamson County, seeking damages, and at the time seeking a permanent injunction. And the evidence as to this adverse relationship or adverse interest is in the testimony of Mr. Dickens. Not only did he testify that he was there in Scurry County seeking to have the Scurry County Court impose a permanent injunction for the case down in Williamson County, he said, as I questioned him in the record, that if the guardian, if for whatever reason they are allowed to intervene and a new guardian is appointed and the new guardian doesn't give him a permanent injunction that he seeks, he'll bring it back to the court. Because he's not here for the protection of the guardian or the ward, he's here for his own pecuniary interests. He's here to make sure that he can sell his property down in Williamson County. He's here to make sure that he gets in place what he hasn't gotten in place down in Williamson County, so that he can go back to developing the land and selling it to make money.
Okay.
And
Do
so,
you, okay. The statutes talk about an adverse party. I assume that you're contending that they are an adverse party.
absolutely, Your Honor, they are an adverse party.
Okay, and I'm looking at some case law now that says this court has held that a person who is suing a proposed ward or incapacitated person has an interest adverse to the proposed ward or incapacitated person, and cites Guardianship of Benavides, Guardianship of Valdez. Is there, but now the question is, under 003, are they an interested party?
No, Your Honor, and let's go to the statute that deals with interested party.
Okay.
And that statute, Your Honor, is that section 1002.018.
Yes, sir.
Okay, and it defines an interested party as an heir, devisee, spouse, creditor, or any other person having a property right or claim against an estate being administered, or to a person interested in the welfare of an incapacitated person. Now,
so why aren't they an interested party under that definition?
Okay, Your Honor, Judge Armstrong held that they don't have a claim. And I think it's important to note that in the definition of claim under section 1002.005, it states claim includes a liability against the estate of an incapacitated person. Now, there is no liability at this point. As you all have already referenced and asked, they don't have a judgment down in Williamson County. In fact, the only thing that they have at this moment is a temporary injunction. They haven't proven damages. They haven't received a judgment that says that the defendants, and not only the estate or the guardian, but the other defendants that they sued, actually caused bullets to damage, to exit or escape the property and enter onto their property, causing damages. They have none of that. They have no liability established against the estate.
Mr. Odell, let's assume that, just for the purposes of argument, we haven't made any decisions, but let's assume for a moment that your position is true, that they're not an adverse party, that they are an adverse party, they're not an interested party, that the court in the motion in limine determined that they don't have standing to be there. What is it that allows this court to then sanction Mr. Wymore's clients for attorney's fees?
Your Honor, as Judge Armstrong held and found in this case, it's because of the bad faith in which these parties proceeded. They brought this motion and intervention seeking to jump into this guardianship proceeding in hopes to have Miss Browning removed as guardian of the estate, in hopes to convince the court in Scurry County to issue an injunction, relief that they were seeking down in Williamson County. He found that the letters that Mr. Dickens continuously wrote to start off with Mr. Browning before he learned that Browning was involved in a guardianship, and next to Mrs. Browning as the guardian, knowing that at all times when those letters were sent, these parties were represented by counsel.
Okay, is
he
there
found that
anything
all
that
of
prevents,
those things.
I'm not aware of counsel, I'm not aware of anything that prevents a party from talking to a party. An attorney cannot talk to the party, a represented party, but an attorney can't counsel his client to talk to another party that's represented by counsel, but a party is not prevented from talking to a party, are they? To resolve their own differences without their attorneys. Is there anything that you know of that prevents that?
Your Honor, let me grab something real quick on the other side of my desk.
Yes, sir.
Now, I think it's interesting that you asked this question, Your Honor. And the reason why I say that is because or the appellants have also argued this position that, that Judge Armstrong must have relied on this communications between the parties, or this rule that attorneys can't do that somehow, that's what he implied. Well, one, there's no implication of that in there. However, he does state that the ethics would dictate that a party knowing that another party is represented should avoid communication. Now, Your Honor, you've referenced Rule 4.02 as well as the appellants. And interestingly enough, when they cite to the comment, I think that's very important. It says, paragraph A, however, does not prohibit communication between a lawyer's client and persons, organizations, or entities of government represented by counsel, as long as the lawyer does not cause or encourage, as you mentioned, Your Honor. Okay, but it goes on to say, encourage the communication without the consent of the lawyer for the other party. It requires consent for these parties to speak, is our position, Your Honor, and that the fact that at these times, none of these parties or the attorneys on our side never consented to Mr. Dickens communicating directly with any of our party, with any of my clients. And so, yes, we do believe that it still is unethical and inappropriate and sufficient grounds to allow for the finding that Judge Armstrong found, which was that constituted unethical behavior for the purposes of harassing Miss Browning in hopes to extract a remedy in Scurry County that they were also trying to seek down in Williamson County.
Okay.
And so,
what's the other evidence? Let's assume for a minute that could be a piece of evidence that the court could use to conclude bad faith. Besides that, what other evidence of bad faith do we have?
well, Your Honor, let me also say that it's not necessarily just to show bad faith.
Mm-hmm.
It's the court under Chapter 10 of the Civil Practices and Remedies Code, Section 10001, has the authority to issue sanctions when a pleading is filed that's groundless.
Correct.
Okay. And as this court has noted,
Rule 13 is the same.
Rule 13.
Right.
Yes, Your Honor. And we believe that the statutes here governing a party's ability to come in to a guardianship proceeding and intervene are clear. When you're adverse, you don't have the right under Section 10055.001 to come in and contest a guardian or the appointment of a guardian. We believe this statute applies. Okay. Second, even if you go to the alternative or look to the statute that appellants have argued, Section 10055.003, first, it requires that you be an interested person. We don't believe that they're an interested person. We don't believe that they have a claim against this estate. They have a lawsuit, they've got allegations, but they don't have a claim. And Judge Armstrong clearly has the discretion and the right to determine the credibility of witnesses. And I think it was certainly within his right to determine that Mr. Dickens' arguments about how he's so concerned about Mr. Browning just weren't credible. He's not there, again, Your Honor, he's not there to make sure Mr. Browning's okay. He's there to get his permanent injunction, get a guardian in place that'll help him in his lawsuit down in Williamson County. And that's what he wanted. And so we don't believe that they're an interested person. So they don't meet that requirement. And even if they did meet that requirement, Your Honor, they're still adverse. And this argument.
What was the timing of the complaint to the CPC? I mean, CPS.
The APS, Your Honor.
The Child Protective Services.
Yes, that was filed in October of 2019. That was filed about a month or so, a little over a month and a half after Mr. Dickens had already commenced this motion to intervene.
Okay.
And so you have the Williamson County lawsuit that started in 2018, a ruling on the temporary injunction, disputes as to what did that ruling mean, the motion intervention in October, and the entry of the temporary injunction order at the end of October, or sorry, at the end of August, and the complaint with APS in October of 2019. And Your Honor, that's another important fact and evidence of continued harassment and bad faith. He's gone back out and he's attempted a new way to try to put pressure on Miss Browning to give in to what he wants. That's what this party has done. It's what appellants have done all this time in Scurry County. They continue to attempt to put pressure to get their lawsuit down in Williamson County. And as this court has pointed out, they have the right to go get those remedies, but they're not doing that. They're not doing that. They're just up here in Scurry County, and they're attempting to get involved in this guardianship.
Why aren't they doing that?
Justice Williams, I think that's a great question.
Is there
the only thing
something
I can tell you
behind
that I know
the
of,
scenes that I don't see? What am I missing here as to why they wouldn't pursue that in Williamson County?
Justice Williams, I don't know the answer to that. It seems to me that if they really wanted to resolve that matter, they could get a judgment. And then if the insurance that's covering that lawsuit isn't sufficient to pay their damages, then they can come present their claim against the estate. And I would assure that a valid claim against the estate would get paid. As you have already heard, Your Honor, and I realize that this is not evidence in the record because this occurred after the appeal, but the property has been sold. Now, what was in the evidence of the record is that the gun range had been shut down at the time that we went to hearing.
Right.
The owner of the gun range shut it down, was no longer operating. Now, the gun range the land has been sold, and for the court's edification, not only was it sold, but it was sold with a covenant that runs with the land that prohibits the operation of any type of sports shooting range on that facility, not just rifles or firearms, but things of archery or anything else. It was a very broad covenant.
So are you telling me the continuing threat as to Mr. Weimer's client's property is no longer there?
It's no longer there based on what they've been arguing, Your Honor. That's correct. The range was shut down before the hearing, and the property's been sold, and there's a covenant in the land that runs with the land that prohibits the firing of prohibits the operation of a sports shooting range on that facility.
Well, if that threat's been eliminated, what dispute exists?
To my knowledge, Your Honor, the dispute that remains would be what are their damages, and again, that's what I'm saying.
If so, what would be the proper forum to litigate that claim?
That would be the Williamson County litigation. That would be where they'd need to take it. Your Honors, I see that my time is up. I appreciate the court's time, and I respectfully ask and pray that this court affirm the lower court's ruling on the motion in limine and the motion to strike, the denial of appellant's motion to intervene, and the granting of the motion for sanctions against appellants. Thank you.
Thank you, Mr. Odell. Mr. Wymore, you're about to have a rebuttal. Your first question is going to be, do we still have a live case in controversy.
We still have a
You may
claim.
begin.
Yes, Judge, thank you very much, and we do. I think this gets back to the very clear language of 1055-003. To qualify as an interested person, you have to have a claim. When I asked Ms. Browning in November of 2019, I asked her on the record, I said, do my clients have a claim against you? Her response was yes. We've given you the most recent annual accounting, the 2018 annual accounting that was filed by the estate. And in that annual accounting, the estate admitted that our lawsuit is a claim. We have a claim. As claimants, we qualify as interested persons. There is no dispute. Here's the interesting thing, Judge.
So what is your claim now?
The claim, it's a claim against the gun range and the estate. What they have done is
A gun range that no longer exists?
They wrongfully denied us the opportunity to sell property for a period of a couple years. There was an investment that was brought to a screeching halt. Because of the pending potential threat of that range, our client was prohibited from selling land. He had millions of dollars at a standstill that he could do nothing with. Lost property not moving results in money being stagnant, results in lost profit and lost opportunity. This was all because the guardian was protecting something that was of no benefit to her son, the ward. Gentlemen, I cannot stress this enough. The one benefit that the guardian got from this was $1,600 a year. At page 34 of the reporter's record, Mr. Rodell said in November of 19, this litigation in Williamson County is heavily disputed. Mr. Wentworth and his colleagues are protesting every piece and part of this litigation. Why? Because the only benefit that the ward and by virtue thereof the estate received was $1,600 a year. They perpetuated this over $1,600 a year. Ms. Browning testified every cent of profit that came out of that range went to her daughter and son-in-law. It didn't go to the ward. They took a very valuable piece of land in Williamson County, put a gun range on it that the estate paid for, and said, go forth and make money. This litigation was perpetuated because Pam Browning didn't look out for her son. She was more concerned about perpetuating financial opportunity for her other child and her son-in-law. They stopped a multi-million-dollar real estate development over pride. We have a claim. Pam Browning admitted we have a claim. Pam Browning's most recent annual accounting acknowledges we have a claim. Appellants are claimants. Mr. Dickens testified on the record that he is interested in the welfare of Stacy Browning. He's not here for sport. Sometimes it's hard to conceptualize these things, but family doesn't always do the right thing, gentlemen. They just don't. Sometimes family does the wrong thing. Sometimes family takes advantage. And sometimes sinful pride intervenes in decision-making. Look at the record in front of you. Pam Browning gave her son one benefit from this range, $1,600 a year. When she realized that the cost of litigating this was consuming that $1,600 a year, when she realized that she was exposing her son to liability, she should have stopped it, and she was. Our case has merit in Williamson County. Why? Because when we put on the evidence, the district judge told him to stop it. They didn't. After the judge issued his decision in December of 2018, they kept firing for 8 months. They kept doing it. They disregarded the district judge's decision, and in doing so, directly exposed the ward and his estate. We didn't expose the ward and the estate to liability. Pam Browning did. She should have been thinking about her son, but she wasn't. She was thinking about the profit of her daughter and her son-in-law. There is an admission. We would ask that this court look at the most recent email from Judge King and the motion to strike. Pam Browning has so flagrantly and blatantly disregarded her duties under the Estates Code. She went over 400 days without filing an annual accounting. She didn't file one for 2019, 2020. You know what happened? Appellants filed a motion claiming that the guardian violated the Estates Code by not filing accountings and by not maintaining an adequate bond. Thankfully, we got a probate judge that truly understands these areas of law appointed. And you know what he did when he looked into it? He appointed an ad litem, because this guardianship is a train wreck.
Mr. Wymore, you're out of time.
Thank you, Judge.
Thank you. With that, the case has been submitted. I'll now call on someone from our clerk's office to adjourn us from court. If you'll please hang with us. Ms. Busk.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.
Thank you very much. Have a
Thank
good
you.
day.
Likewise.